I'm Dr. Chaudhry, and welcome to FSMB Spotlight. Our guest today is Tara Koslov, the Acting Director of the Office of Policy Planning at the Federal Trade Commission, the FTC. She's been in that role since July of 2016. Previously, from 2011 to 2016, she was the office's Deputy Director. She's also a council member of the American Bar Association section on antitrust law. She's a distinguished graduate of Brown University and Harvard Law School. Earlier this year, the FSMB's DC staff had the opportunity to meet with her and several of her staff to discuss various topical issues. Tara, welcome.
Thanks so much for having me. I'm happy to be with you today. Of course, I can't say that I represent the views of the Commission or any of the commissioners, but I've been at the FTC for quite a long time, and I'm happy to share my views.
Very good. Thank you for that. So speaking of the FTC, it's an agency that's been around since 1914, 2 years after the Federation was established. Large agency, right? Large administration, about 1,000 employees. Tell me about your office.
So I'm the Office of Policy Planning. I'm the acting director. And when people talk about the FTC, we're primarily a law enforcement agency, but when you look at our enabling statute, we have specific authority to engage in various kinds of research and advocacy and scholarship, and my office is the office that does a lot of that. And so we do things like stakeholder outreach, we run workshops, we write reports, and we engage in a lot of competition advocacy, trying to get our competition message out to other decision makers out there.
Very good. So the Supreme Court's 6-3 decision 2 years ago in North Carolina Dental versus FTC, as expected with probably almost any Supreme Court decision, has begun to have some consequences on state-based regulation, and not just for medicine. The decision has impacted a number of regulators across the country. Give me a sense of your perspective on how the FTC views something like that.
So we were certainly happy with the outcome of that case. It was many years of effort that we invested in pursuing it. The way that I typically describe the outcome in that case is that it didn't really change the substantive law, the underlying law of the state action doctrine, which is the doctrine of whether actions by people working in government or working for boards can get antitrust immunity. What that case really did was clarify to whom the active supervision prong applies, and so basically whether boards need to be actively supervised. And that decision stated that if you're a board that is controlled by financially interested market participants, you do need to be actively supervised by the state government in some way to be entitled to state action immunity.
So every case has intended and unintended consequences, right? So one of the unintended consequences of this particular case was its impact on lawsuits. So we've begun to see across the country examples of individuals who feel that their state boards did them wrong, and they're citing the antitrust case. Tell me about how the FTC views this development, which, as I say, from the state regulator's point of view, is an unintended consequence.
So I certainly would want to comment on private litigation as opposed to FTC litigation, but I can tell you my views of how I would filter what's going on in the private litigation scene. So all of the actions that boards engage in, if you think of them like a pyramid, there's lots of things that boards do every day that don't have any impact on competition. And then there's kind of this middle category of things that a board might do that might affect competition in some way, but do not violate the antitrust laws. And then you've got this little tiny tip of the pyramid where you have actions that could potentially violate the antitrust laws unless you're then entitled to state action immunity. I think what's happening is that we're seeing a lot of activity in private litigation in that middle zone, where there are activities that the boards may engage in that may affect competition in some way. So you're an individual license holder or practitioner, and for whatever reason you lose your privileges, you lose your license, you feel you've now been excluded from the market, so you bring a suit against the board. The FTC has long indicated that those kinds of actions would not violate the antitrust laws. They might affect an individual competitor, but they do not really affect competition as a whole, and there's no reason that those would violate the antitrust laws. So certainly we're seeing private litigation there, but I wouldn't expect those are the kinds of cases that the FTC would choose to bring.
And I know the FTC did put out a guidance to, so my sense is one of the reasons perhaps of that guidance was to maybe avoid some of those unintended consequences.
Right, so what that guidance was intended to do, as I indicated, the NC Dental case did not change the underlying substantive law of what it means to do adequate active supervision. It just clarified to whom that applies. So what we saw was we now had a whole lot of people, especially people working for and serving on state boards, who had never even thought about active supervision before because they just assumed it didn't apply to them. And all of a sudden they had all these questions, well, what does it mean to be actively supervised? And certainly state governments and state legislators were grappling with that as well. And so the purpose of that guidance was to lay out the FTC's interpretation of what it means to engage in adequate active supervision. But that guidance does also provide certain categories, such as this individual credentialing decision, where we wouldn't even think that that would be an antitrust violation in the first place.
And those continue to be questions about that. And I wonder, the FTC, I know in recent months, has really tried to do more outreach. You've had at least 2 roundtables, one on licensure portability, and we appreciate the opportunity to talk about the Interstate Medical Licensure Compact. You've also had one on just occupational licensing as a whole. Tell me a little bit about the FTC's desire, certainly in the last couple of years, to be more involved in outreach. Is it because there are so many questions out there?
So occupational licensing has long been an issue of importance to the FTC, going back really to the 1980s, where we've engaged in a lot of research and scholarship on that issue. In the last couple of years, we've really seen this moment where many different stakeholders are focused on occupational licensing. When Acting Chairman Olhausen was named acting chair in January, one of the first initiatives that she announced was the creation of an economic liberty task force. And one of the main things that that task force is doing is focusing on occupational licensing. And so I was asked to lead that task force, and my office has been very involved with that. And so what we've really been trying to do is delve into, for situations where there are occupations that clearly should be licensed, medicine certainly being one of them, are there ways that we can streamline licensing or remove some of the entry barriers that complicate the licensure process? And then as well, we're looking at whether there are some occupations that are licensed that perhaps don't need to be licensed, especially the kinds of occupations that are maybe licensed in some states but not all states, and trying to compare. But with respect to medicine and other healthcare professions, we've really been trying to shine a spotlight on issues relating to license portability, and such as interstate compacts and model laws, and really trying to push for greater reciprocity and portability. There are a lot of people that benefits. It benefits everyone who's working in the profession who might want to move around. It helps people respond better in emergency situations where you might want to bring experts and professionals from one state into another state. Military spouses and families are among those that we're really trying to help, because trailing spouses also have struggle when they have to move from state to state. So there's a lot of reasons we've been focused on portability issues.
Thank you, Tara, for sharing a lot of insight on what's going on. We also appreciate the opportunity to have continued dialogue with your office and with the FTC. I want to thank you for your time.
Thanks. Thanks for having me.
Thank you for joining us. Stay well, and see you next time.